Hello, my name is Jerry Cherry, and today I will be doing a training video that will provide information to help a new scientist or witness testify in trial for the very first time. I am a police officer with the Metropolitan Police Department located in Washington, D.C. I have over 10 years of experience, and during my career, I have testified in multiple cases as a patrol officer and as an investigator. So first, I would like to go over the three phases of testimony. The first phase is direct examination, the second phase is cross-examination, and the third is redirect. During direct examination, this is where the witness is questioned by the attorney and who called them to be an expert witness in a case. During this phase, the expert is asked questions that would prove the facts of that party in which they're representing. Cross-examination is where the opposing attorney will ask questions of the witness to try to discredit any statements or anything that was given during that witness testimony during the direct examination. And as I stated, that the goal of this attorney is to just poke holes in that witness testimony any way possible. Next is the redirect examination, and during this phase, this is where the initial attorney that did the direct examination comes back to re-examine that witness in order to address any issues or any inconsistent questions that were asked during the cross-examination. Their goal is to reestablish the witness credibility to the jury based on the testimony that they gave. Next, I will give recommendations on how to prepare for trial as a forensic expert when they do and do not meet with the attorney before trial. So prior to testifying, it is recommended that the witness meets with the attorney which they're representing. During that meeting, this is where the case will be evaluated. Any information that needs to be exchanged between the expert and the attorney based on like scientific facts or any type of legal wording or information that needs to be further explained. This is a time where both the attorney and the expert can build a rapport with each other, that the attorney can go over types of questions that the expert may be asked while on the stand. And you just want to make sure you go over all the facts with the attorney so you know exactly what to expect when you get on the stand to testify. When the expert do not have the opportunity to meet with the attorney due to the fact that the attorney is too busy or unable to get in contact with the attorney, as an expert, it's your responsibility to make sure you prepare as much as possible for that case before going to trial. So you want to go over all your case notes, all of your tests that you did, all the information pertaining to this case. You want to make sure you know it front to back. You want to critique yourself, and one way to critique yourself is to practice testifying in front of a camera. That way you can go over any of your flaws and address those issues before you take that stand. If you have to, you want to prepare any demonstrative aids or visual aids that will help further explain your testimony to the jury when you do take the stand. So if you don't get a chance to speak with that attorney or meet with that attorney, you just want to make sure you prepare yourself as much as possible before you give any type of testimony. Next, I'm going to go over reasons why an attorney can object to questions asked by an opposing counsel. So whenever an objection is made to a question, at that time the witness would stop answering the question or stop giving further information and be instructed by the judge as to either continue answering that question or to not continue to answer that question, and a new question will have to be asked. So reasons that can take place, some of the reasons why that can take place, according to the text, successful expert testimony, written by Max Huck, Christine Funk, and Harold Fetter. The text suggests 8 reasons why this can take place. I'm only going to go over some of those reasons. To begin with, I'm going to go over that some questions may be objected to based on relevance of that question. Basically, the question that is being asked has nothing to do with the case at all. So that question can be objected to by the initial attorney if the opposing attorney is asking any questions that has nothing to do with the case at hand. Next, the question can be a leading question, meaning that the answer is only yes or no. So the opposing attorney is only asking questions that they already know the answer to. And the only answer you can give is a yes or no answer. That question can be objected to because leading questions are not allowed during cross-examination. They are allowed during direct examination, but not cross-examination. The question could be a compound question, meaning that the question has multiple questions in one, which can confuse the jury, the witness, and also the judge. So that question can be objected to. The question is too argumentative. So the attorney is asking questions in which they are trying to go back and forth with the witness on the stand, which is not allowed. That type of questioning is also known as badgering the witness. So those type of questions can be objected to. And also the question itself just lacks any type of foundation. So basically the question that's being asked to the witness are questions that the witness are not qualified to answer. Next, I'm going to discuss how to identify a compound and leading question. So according to the text, The Helpful Guide for Witness Preparation by the Sharp School, they suggest that a way to identify a compound question is that the question itself has a double meaning, and that the facts in the questions are not true. So the only way to give an answer is to give a yes or no answer. And the best way to answer those type of questions is if you actually know that the answer is going to be yes, then it's best to just answer the yes or no question as it is. If you don't understand the question, before giving your answer, just politely ask that attorney, can they split that question into multiple parts, or if they can rephrase the question for better clarification. A leading question is a question that, as I stated before, the attorney already knows the answer to. They're basically leading you into answering that question with a yes or no answer. Excuse me. And the best way to address those types of questions is if you need to further clarify your answer in addition to saying yes or no, then do so for context, but do not go into too much detail and do not be very wordy with your answer. You want to keep it short and to the point. Next, I want to discuss how an expert can enhance their direct examination. So, one reason the expert can enhance the direct examination, according to the text Successful Expert Testimony, is to coordinate their verbal testimony with actual documentation. So what this means is, while you're giving your verbal testimony, it's important to be able to back up that information with some type of factual proof or documentation that would coordinate your verbal testimony. So you want to provide facts with your testimony. Just basically stating that you did something is not going to be enough to get a jury to believe that your tests or the results that you came up with is accurate. They want to be able to visualize the information that you're telling them. So to help with coordinating your verbal testimony with actual documentation, I would suggest using some type of visual aid, actually showing a like a demonstration, using like handouts that you can print off and actually pass out to the jury to just give them a better clarification of the information that you're providing them. So next I will discuss goals that opposing counsel can use during cross-examination. So according to the text, Successful Expert Testimony, some of the goals that they suggest is the opposing counsel can make the expert their witness, basically getting the expert to answer questions that would favor their theory of the case. They can attack the expert's field of expertise, which can show that the expert lack of recognition of the professional field that the expert has experienced, and they can attack their resume, show any gaps that may be on the resume, and they can also use that against them. They can also expose that the expert has biases. Also, they can impeach the expert witness based on any type of journals or writings or any type of text that they find. They can use that information against the expert to try to impeach them in their credibility. Next, I'm going to discuss how to reduce vulnerability during cross-examination. So when, as an expert or any type of witness, get up on the stand, of course you're going to be nervous and have some type of fears of testifying, but you don't want to allow those fears to interfere with how you give your testimony. So if you get up on the stand, you show any type of fear or weakness, that can be used against you on the stand, and that can affect your the way in which you testify. It can also show that you do not that you lack the ability to recognize issues and complex questions, and you're unable to know how to properly answer those types of questions. And it can allow you to be vulnerable on the stand. So I would suggest to remain calm, speak clearly and slowly when you're answering these questions. Like I said, identify whatever weaknesses you have and address those weaknesses before you take the stand, and practice also. Practice makes perfect. As much as you can practice in a mirror, on camera with the attorney, I would suggest doing that, and that will give you an idea of what to expect. That way you can better improve your testimony. I hope this video can assist anyone who's may be having issues or just need some advice on how to testify on the stand. Thank you.